As we have embarked on the series with Justice V. RAMKUMAR on sessions which facilitate to understand the law in the criminal jurisprudence in a different perspective, which have more practical aspects to be learned. And we have seen that these sessions have actually been picked up like anything. So we keep on requesting Justice V. RAMKUMAR, and he happily accepts it because he believes, like the team of Beyond Law CLC, that it's the time to repay back to the society. And today's session will be delving upon trial of summons case instituted on a complaint. And we are thankful to Justice V. RAMKUMAR for accepting our invite. Over to you, sir.
Thank you, Mr. Vikas. Good evening, friends. The other day, during the other session, we discussed trial of summons cases instituted on a police report falling under Part A of Chapter 20 CRPC. Today, we are discussing the procedure of trial of summons cases instituted on a complaint, loosely called private complaint. This falls under Part B of Chapter 20 CRPC. The relevant sections are Section 251, that is the substance of accusation to be read over and explained to the accused. Then comes Section 252, conviction on his pleading guilty, voluntarily pleading guilty without a trial. Then Section 254, procedure when not convicted under Section 252. Here the trial starts. Actually, trial starts here only, 254. Then after the prosecution evidence is over, accused is examined under Section 313 CRPC. Then the discussion on merits, 255, Section 255(1), acquittal on merits. Section 255(2), acquittal on, rather conviction on merits, unless the magistrate invokes Section 325 or 360 CRPC as the case may be. Then Section 255(3), subsection 3, conviction also for proved or admitted offences. Offences which have been proved or admitted, the accused can be convicted for them also. Then comes Section 256, non-appearance or death of the complainant. What happens? Now, this has no application in police charge because their state is the complainant. There cannot be death of the state. Then comes 257, withdrawal of complaint. This has no application in police charge case because there the charge sheet is laid by the police. The state is the complainant. Then comes 259, power to convert summons into warrant case. Summons case into warrant case. Now we will examine the stages, the provisions stage by stage. So trial of summons case instituted on a complaint. On a complaint means private complaint. First step is supply of copies to the accused. If he is already not supplied with the copy of the complaint, etc., along with the summons, court will ensure, magistrate will ensure that he is supplied with copies of the complaint, documents produced along with the complaint, etc., and sworn statement of witnesses, etc. Then 251 is the starting of the first step towards starting of trial. But then once trial starts, Adalat Prasad versus Rupalal Jindal, AR 2004 Supreme Court 4674, and Subramanian Seduraman versus State of Maharashtra, AR 2004 Supreme Court 4711, have taught us that once trial starts, there cannot be any midway stoppage, any stopping of the trial midway. There cannot be any dropping of proceedings or the stopping of proceedings midway. Court, the trial has to go on and until it reaches a final stage of acquittal or conviction. Therefore, there is no via media in between. Therefore, once trial starts, the magistrate cannot stop the proceedings. Magistrate cannot put a premature stoppage of the proceedings. Magistrate cannot terminate the proceeding prematurely. But if the substance of accusation to be read over to the accused does not contain the offence at all, deal of a trial, we in Kerala, we judges in Kerala have taking the cue from Adalat Prasad and Subramanian Seduraman have taken the view that taken the view that the before trial, before the commencement of trial, if the substance of accusation does not contain the offence, does not make out the offence, then the court can, the magistrate can stop the proceedings by not reading out the substance of accusation and by commencing the trial. The court can say that the substance of accusation does not contain the ingredients of the offence, and there is no meaning in asking the accused to face the trial. Accordingly, the court can drop the proceedings. So, this is a via media, rather, even before the commencement of trial, magistrate can stop the proceedings by not reading out the substance of accusation, by not reading out the particulars of the offence to the accused, and thereby put an end to the ordeal which he may have to face if trial were to commence. Then comes the real trial. Now, how to state the substance of accusation? Now, supposing the substance of accusation contains the ingredients of the offence is made out by the substance of accusation, then the substance of accusation will have to be read over to the accused. Trial has to start. How to read the substance of accusation? Mere reading of the complaint filed by the complainant is not sufficient, but the particulars of the offence must be explained to the accused in the language known to him. The magistrate should state the necessary ingredients of the offence. Accused should be apprised of the substance of accusation, and it should be made clear for what he is being tried. He should be told that he is being tried for such and such offence, the particulars of which are the following. That is the substance of accusation being read over to the accused. There's an old Kerala ruling by Justice P. Govinda Menon, who was subsequently elevated to the Supreme Court. State of Kerala versus Raman Nair, 1961 KLT 465. The corresponding criminal law journal is 1962 1 Criminal Law Journal 429. Justice Govinda Menon. The manner in which the substance of accusation is to be read over to the accused has been very beautifully stated by Justice Menon. Then, so as a natural corollary, substance of accusation should disclose the offence. The substance of accusation read over to the accused should disclose the offence. When the substance of accusation read over to the accused, the magistrate should bear in mind that same does disclose the ingredients of the alleged offence. Otherwise, if the accused were to plead guilty to the substance of accusation, his plea may only amount to an admission of the facts stated in the substance of accusation, which is devoid of the ingredients of the offence. In that case, we cannot say that he has pleaded guilty, because there is no substance of, the ingredients of the offence is absent. So even if he pleads the substance of accusation to be true, he is only saying that I admit the facts stated therein. But the facts stated therein do not complete the offence, do not make out the ingredients of the offence. So merely because he pleads guilty, you can't say in the eye of law that he has pleaded guilty to the offence. This is what the Kerala High Court, speaking through Justice Subramaniam Poti, beautifully stated in State versus Gopinatha Pillai, 1978 KLT 779. Now, if the trial of the summons case, there is no. Now, it was also highlighted that there is no framing of charge. Unlike in a warrant trial, there is a framing of charge. Charge is to be framed by the court. But in a summons trial, there is no framing of charge. Only the substance of accusation, that is the particulars of the offence, will be read over by the magistrate to the accused and explained to him. Now, if the substance do not contain the ingredients of the offence, there is no point in reading over the substance of accusation to the accused, and the court can terminate the proceeding at that stage itself, taking the cue from Adalat Prasad and Subramanian Seduraman. Therefore, he should not be subjected to the ordeal of a trial thereafter. So it is only when substance of accusation contains the ingredients of the offence, the magistrate need read that substance to the accused and take his plea. Now, after reading the substance of accusation, the magistrate will ask him, Mr. Accused, whether you plead guilty or not guilty. Then comes section 252, the next section. Conviction on pleading guilty. Now, the section says, if the accused plead guilty, the magistrate shall record the plea as nearly as possible in the words used by the accused himself and may, in the discretion of the magistrate, convict him thereon. So, supposing the accused pleads guilty, that plea of guilt by the accused should be recorded by the magistrate in the very same words used by the accused, which we usually call by invoking a Latin maxim, ipsissima verba. The plea of guilt by the accused should be recorded in the very same words of the accused. Accused might say some words while pleading guilty. His own words should be recorded by the magistrate while recording the plea of guilt. Ipsissima verba, in his own words. Then conviction on plea of guilt may stop the accused from challenging the conviction. See, it is a very crucial stage when the substance of accusation is read over to the accused by the magistrate and explained to the accused in the language known to him. The magistrate is discharging a very crucial, very important role, very significant role. The magistrate has to be very careful because once the ingredients of the offense are there and the accused pleads guilty and he can be straightaway convicted. The magistrate can straightaway find him guilty, convict him, and impose an appropriate sentence on him. So once he voluntarily pleads, only precondition is that magistrate should be satisfied that the accused is pleading guilty voluntarily, that is without any extraneous influence or pressure. Nobody has influenced him. He is on his own pleading guilty. Maybe because of the prick of conscience. He may be having the prick of conscience to say that it is an offense which I committed. Why should I tell a lie before the magistrate? I did commit the offense. So he is pleading guilty voluntarily. The magistrate is satisfied. The magistrate can straightaway convict him. But then, once he pleads guilty and he is convicted, then he cannot thereafter turn round and challenge his conviction. It is true that I pleaded guilty, but I can still contend before the appellate court, before the superior court, that what I pleaded was not correct. I did not plead guilty. That was not the plea of guilty. No, he is stopped from stating otherwise. Once he pleads guilty and he is convicted. This is because under section 375 CRPC, there is a bar of appeal. He cannot challenge the conviction if he has been convicted on his plea of guilt. If he was convicted on his own pleading guilty, then he cannot challenge the conviction because he admitted the offense. Since he admitted the offense, he cannot thereafter say that I did not admit the offense. He admitted the offense, therefore, his conviction cannot be questioned by him in an appeal. But he can challenge the legality and extent of the sentence. Legality and extent of the sentence he can challenge. Because there he did not ask for any particular sentence. So, depending on the facts and circumstances of the case, he can say that the sentence imposed on me, of course, I pleaded guilty, but the sentence imposed on me is on the harsher side. It is very harsh. Please reduce the sentence. That he can plead. That alone he can plead. Then the bar against challenging the conviction does not make out any offense. Now, as I mentioned earlier, supposing he pleaded guilty to the substance of accusation, which does not contain the ingredients of the offense, he is only admitting the substance of accusation, which does not contain, which is devoid of the ingredients of the offense. In such a case, he is not stopped from challenging the conviction also because he did not plead guilty. There is nothing to be pleaded guilty. In such a case, as I mentioned the earlier decision by Justice Subramanian Poti in Gopinatha Pillai, 1978 KLT 779, there his lordship said, if what he pleaded was only the admission of the substance of accusation, which is devoid of the substance, the ingredients of the offense, then he is not stopped from challenging the conviction also. He can challenge the conviction as well as the sentence. Supposing this conviction goes, sentence also will go. Conviction on plea of guilt is discretionary. Even when the accused pleads guilty, the section says the magistrate may, in his discretion, convict the accused. Therefore, even when the accused plead guilty, the magistrate is not bound to convict him. Notwithstanding the plea of guilt, the magistrate can call upon the prosecution to prove the case of the accused, case of the prosecution against the accused. This is something like, this is an extension of the principle of Section 58 of the Evidence Act. Under Section 58 of the Evidence Act, an admitted fact need not be proved. Supposing in a dispute between two parties, one party admits the allegations of the other, then why should you prove that? He is already admitting that. Therefore, the other party need not prove it. That is what the principle laid down contained in Section 58 of the Evidence Act. But even there is a proviso. Notwithstanding the admission, the court may call upon the other party to prove the allegation. I make an allegation against B. B initially disputes that. Then subsequently coming to court, he says, I admit the allegation. So when B admits the allegation, I need not prove my allegation. But court may say, he has not fully understood the allegation. That is why he is admitting the allegation. You prove your allegation. Court can still say, notwithstanding his admission, the opposite party should prove the allegation. Same principle is there in Section 252 also. Notwithstanding the plea of guilt, court can refuse to convict him and call upon the prosecution to prove its case. That is why the court in its discretion, that's why the words court in it, the magistrate may in his discretion convict the accused. Now, one thing to be borne in mind is when the accused voluntarily pleads guilty and the magistrate straightaway convicts him, there is no trial. Prosecution is not called upon to examine its witnesses and prove its case. There is no trial at all. That is why I said, just because the accused, then yet another principle is, so now here's a case where the accused has voluntarily pleaded guilty. So the magistrate may be inclined to give him a leniency in the sentence. No. Once he pleads, the effect is same. Whether he pleads not guilty and the court ultimately finds him guilty, or whether he pleads guilty and the court convicts him, the consequence is same. The punishment should be the same. The punishment to be imposed should be the same. Just because he pleaded guilty, it is not an incentive for the magistrate to reduce the sentence. This is what Justice V.R. Krishnaiyer observed for the bench in Muralidhar Megharaj Laya versus State of Maharashtra, AAR 1976, Supreme Court 1929, corresponding to 1976 3 SEC 684. Justice V.R. Krishnaiyer and P.K. Goswami are the judges. Justice Krishnaiyer being the author. Then under Section 255(3), apart from convicting the accused for the alleged offence, he can be convicted also for any other offence which has been admitted or proved. He can be convicted for any other offence which has been admitted or proved. That is enabled by Section 255(3) CRPC, subsection 3 of Section 255. Now we pass on to Section 253. Now 253 has no application here because we discussed 253 in summary trial while dealing with petty offences. 253 has no application in summons trial on a complaint, because we are not dealing with petty trial. Now, once the accused, either accused pleads guilty, but the magistrate does not convict him, the magistrate can do that. Or the magistrate or the accused pleads not guilty and claims to be tried, then we pass on to section 254 CRPC, where the trial proper starts. Trial proper starts under section 254 in a situation where if the accused is not convicted under section 252, even after he pleading guilty, the magistrate has got the discretion. Or the accused does not plead guilty. I don't plead guilty. I did not commit this offense. I may be tried, or claims to be tried. Then in such a case, the magistrate has to call upon the prosecution to produce all its evidence. You bring all your evidence in support of your case. That is 254. Then the section says prosecution shall produce all such evidence in support of the prosecution. So produce, the word produce does not mean that the entire liability is on the prosecution. The court has also got a duty to enforce attendance of witnesses by issuing process under section 254 to CRPC. This has been highlighted by the Madras High Court, speaking through Justice Paul in State versus Veerappan, AIR 1980 Madras, page 260. AIR 1980 Madras, page 260. Now, the prosecution has been asked to produce all its evidence. Prosecution has produced all the evidence. After the prosecution evidence is over, supposing there are materials incriminating, there are materials which point a finger towards the accused, towards the complicity of the accused, then the accused has to be examined under section 313 CRPC. Now, in a summons case, the magistrate can dispense with the attendance of the accused during trial by passing an order under section 205 CRPC or 317 CRPC. Now, in a case where the personal attendance of the accused has been dispensed with, the magistrate need not examine the accused under section 313 CRPC. The magistrate can ask the questions to the counsel who was appearing for the accused. But where the accused was present during the trial, because he has a right to be present under section 273 CRPC. So when the accused was present during trial, the magistrate has to examine him with regard to the incriminating circumstances appearing in the evidence for the prosecution, with a view to enable the accused to explain those circumstances. There may be, supposing some witness had said that he saw the accused beating the victim with a stick. The accused may say that, true, I beat him with a stick, but it was in self-defense. He was the aggressor. He was attacking me. Therefore, I was defending the aggression by beating him with a stick. So he may have so many explanations for each and every incriminating circumstance in the evidence for the prosecution. That is why this is an extension of the principle of audi alteram partem. No person shall be condemned unheard. No person shall be condemned unheard. So a right of hearing is given to the accused with regard to the incriminating circumstances appearing against him in the evidence for the prosecution. Each circumstance has to be put to the accused and his explanation has to be elicited. Now, Supreme Court has gone to the extent of saying that if a particular incriminating circumstance was not put to the accused and his explanation elicited, then that particular circumstance cannot be used by the magistrate for recording a conviction against the accused. A circumstance which was not put to the accused and his explanation was not sought should not be used against him for convicting him. You may usefully refer to Sharad Birdi Chand Sharda versus State of Maharashtra, AIR 1984 Supreme Court, 1622 corresponding to 1984 volume 4 SCC 116, the dictum by 3 judges. The as Murtaza Fazal Ali, A. Varadarajan and Sabyasaji Mukherjee. They were the judges. Then we pass on to section 255. Now we have now the trial has started. Now trial is coming to a close. 255(1), acquittal on merits only after evidence. Now as per section 255(1), an accused can be acquitted of the offence only after merits, only after the prosecution has adduced entire evidence in support of the prosecution by producing witnesses under section 254(1). Now, the courts have taken the view that an acquittal without doing support, it is the duty of the court also. Courts have taken the view that it is, though it is the, going by the section, it is the duty of the prosecution to produce all its witnesses. Prosecution can only ask for summons to a particular witness. It is for the court to enforce, to issue summons and enforce its execution. Therefore, court has also got a duty to ensure that prosecution witnesses are properly summoned, and if not summoned, they are brought before court by issuing coercive steps like warrant, etc., and brought before court for deposing the truth before court. Therefore, courts have taken the view that the court has also got the duty to help aid the prosecution for producing their witnesses. This is the same decision, State versus Veerappan, which I referred to earlier. AR 1980 Madras 260. AR 1980 Madras 260. There's a Kerala decision also. Shantamma Radhamaniyamma versus Kunju Pillai 1980 KLT 393, corresponding to 1981 Criminal Law Journal 247, rendered by Justice S.K. Kadar of the Kerala High Court. That is 255(1). There, even though the duty is on the prosecution, court has also got an obligation to help the prosecution in producing the witnesses. I'm sorry. We pass on to section 255(2) CRP. Now we notice that accused is to be acquitted only after evidence under section 255(1). Now under section 255(2) also, accused can be convicted only on the strength of evidence adduced by the prosecution. Now where the magistrate does not acquit the accused under section 255(1) CRPC, and where he does not decide to submit the case, the section says accused to be found guilty on merits unless the magistrate proceeds under section 325 or under section 360 CRPC. If the magistrate decides to proceed under section 325, he cannot straightaway convict the accused and pass a sentence. Likewise, if the magistrate, after finding him guilty, wants to give him admonition under the Probation of Offenders Act or under section 360 CRPC, or wants to let him on probation, let him go on probation, then there's no sentence imposed. So even after convicting the accused, the magistrate will not pass a sentence if he is proceeding to let the accused on probation under section 360 or under the Probation of Offenders Act. Likewise, if the magistrate is of the opinion after the trial, but magistrate is yet to pronounce judgment, after the trial, the magistrate is of the opinion that this is a fit case where the accused should receive a harsher punishment. He can, magistrate of first class can impose a sentence of imprisonment only up to 3 years. Now he feels that this particular accused should receive a higher, graver, more stringent punishment. So he can invoke the power under section 325(1) CRPC and submit the entire case to the Chief Judicial Magistrate. When he so submits, the Chief Judicial Magistrate may recall some of the witnesses and may even further adduce further evidence and finally convict the accused or acquit the accused. And if he convicts the accused, he can even impose a sentence beyond 3 years, which is the upper limit of the magistrate of first class. Upper limit of the sentencing limit of the upper limit, the magistrate of first class. Now, therefore, after the prosecution adduces evidence under section 254, 256 CRPC, then 254 CRPC, and the evidence is to the effect that the accused has committed the offense, then if the magistrate does not invoke section 325 by submitting the case to the CJM, Chief Judicial Magistrate, or does not invoke the provisions of the Probation of Offenders Act, then the magistrate has to find the accused guilty and impose an appropriate sentence on him under section 255 2 CRP. Then comes section 255 3. Now, as we found in under section 252, when the accused pleads guilty, he can be straightaway found guilty and sentence can be imposed on him. And while imposing the sentence, we notice that the power under section 255 3 also can be exercised by the magistrate by finding him guilty also for an offence which is either admitted or proved by the evidence. Likewise, when the final conviction comes after trial, there also the magistrate can invoke section 255 3 CRPC and find him guilty not only of the offence he has been found guilty after trial, but also for any other offence which is either admitted or proved by the evidence. That is the power under section 255 3. Then comes section 256 CRPC. Non-appearance of the complainant. We are dealing with a summons case instituted on a private complaint. Supposing in a summons case, when the complainant is absent on the date of hearing, the 3 courses open to the magistrate are: 1, the accused may be acquitted because a complainant is absent. Why should the accused be allowed to undergo the trauma of a trial? He can be acquitted under section 256. Second option, the case may be adjourned to facilitate the prosecution to adduce evidence if any. Third option, the magistrate may proceed with the trial if personal attendance of the complainant is not necessary. Supposing complainant is absent, but his personal attendance is not necessary having regard to the stage of the case. In that case also the magistrate cannot acquit the accused and penalize the complainant. A discretion is vested with the magistrate to adjourn the case even though the words used are: if the complainant does not appear, the magistrate shall acquit the accused. Even though it is worded, couched in such a peremptory words, such a mandatory word, courts have taken the view that it is not necessary that invariably in every case, the magistrate should acquit the accused. Hence, if the magistrate in his discretion adjourns the case, it cannot be said that the order is either improper or illegal. This is what the Kerala High Court, speaking through Justice K.P. Balanarayana Marar, held in Sundaresan versus M.S. Hardways, 1995, Volume 1 KLT 689. Again, the conduct of the complainant plays a significant role. This is what the Supreme Court said in S. Ramakrishna versus S. Rami Reddy, AIR 2008 Supreme Court 2066, corresponding to 2008 5 SEC 535, Justice S.B. Sinha and Justice L.S. Panta. Justice S.B. Sinha being the author of the judgment. The conduct of the complainant also plays an important, significant role in a case where he remains absent. So it is not, it may be innocuous, it may be very innocuous absence, or it may be deliberate absence. Court has to see the conduct of the complainant in remaining absent on a particular day. Then the accused is under an obligation to attend the court on all the posting days. He will be put to much harassment if the complainant were to practice dilatory tactics. The complainant were to practice dilatory tactics, the accused would be put to untold harassment. Therefore, Section 256 affords a protection to the accused against such tactics practiced by the complainant who remains absent. The magistrate in such a case would be justified in dismissing the complaint and acquitting the accused under Section 256 CRPC. But the discretion to acquit the accused or to proceed with the trial must be exercised judicially and fairly without impairing the cause of justice. That should be the guiding rule for the magistrate. If the personal attendance of the complainant is not necessary on a particular day, the magistrate has the power to dispense with his attendance and proceed with the case. It is only in a situation which does not justify the case being adjourned can the magistrate dismiss the complaint and acquit the accused. This is the word of caution given by the Supreme Court in Associated Cement Company Limited, Keshavanand. Associated Cement Company Limited versus Keshavanand. AIR 1998 Supreme Court 596 corresponding to 1998 1 SEC 687. Justice M.K. Mukherjee and Justice K.T. Thomas. Justice K.T. Thomas being the author of the judgment. Again, when the complainant in a case is a body corporate, it is the de jure complainant. The body corporate is the de jure complainant, and the de jure complainant has to be represented by some human agency. No magistrate shall insist that the particular person whose statement was recorded on oath at the first instance alone can continue to represent the company till the end of the proceedings, because the company is governed by individuals. Very often they may change. Therefore, the magistrate cannot insist that the very same person who was examined on oath under Section 200 CRPC while the complaint was filed should be present throughout, should be the person representing the company throughout. No, magistrate cannot insist that. There may be occasions when different persons may have to represent the company. Only thing is they will have to show the appropriate resolution showing that the earlier person has ceased to hold office. There is a subsequent person. Next incumbent is the person who is now present before magistrate. The same decision. Associated Cement Company Limited versus Keshavanand. AR 1998 Supreme Court 596. Justice M.K. Mukherjee and Justice K.T. Thomas. Justice K.T. Thomas being the author of the judgment. In a case where the magistrate had given several adjournments, still the complainant did not appear, and his witnesses were also not present, and there was no representation also in court, it was held that the magistrate was justified in dismissing the complaint and acquitting the accused under Section 256 CRPC. Manual versus State, 1984 KLT 859. The judge is Justice Bhaskaran Nambiar of the Kerala High Court. We now pass. We are now going to consider the other contingency referred to in Section 256 CRPC. 256, Section 256 refers to two contingencies. One, absence of the complainant. Two, death of the complainant. Supposing the complainant is no more, such a contingency will not happen in a summons case instituted on a police report, since in such a case the de jure complainant is the state itself. State is the complainant. There cannot be death of the state. So it can happen only in a summons case instituted on a private complaint, as the present one. There is no specific provision in the CRPC to the effect that on the death of the complainant, the complaint will abate. No provision. Unlike in a criminal prosecution, in a prosecution in a police charge, like an appeal of being awaiting 394 etc. Adjourning the case consequent on the death of the complainant is within the power of the magistrate under section 256 CRPC. If in the meanwhile one of the legal representatives of the deceased complainant or an otherwise fit and proper person comes forward seeking permission to continue the proceedings, it is within the power of the magistrate to permit such person to continue the proceedings. This was so held by Kerala High Court in Shanti Balagopalan versus um, Benilde, 1992, Volume 2, KLT 488. 1992, Volume 2, KLT 488. This is Balanarayana Marar of the Kerala High Court. Because the power does exist under section 302 CRPC to permit for the magistrate to permit any person to continue the prosecution. Upon the death of the complainant, his legal heirs can file a petition under section 302 CRPC seeking permission to continue the prosecution. That is a decision by Supreme Court. Bala Sahib K. Thackeray versus Venkat, 2006, Volume 5 SEC 530, corresponding to 2006 3 KLT 509. Judges are Justice Arijit Pasait and C.K. Thakkar. Justice Arijit Pasait being the author of the judgment. His Lordship held that in the eventuality of the death of the complainant, the court can permit under section 302 any person, any legal heir coming forward to continue the prosecution. Any of the legal heirs. Again, even though the absence of the complainant on the day fixed for the hearing may entail the dismissal of the complaint and acquittal of the accused, in a case where the absence of the complainant is due to his death, the 256 contemplates two contingencies. One, absence of the complainant. Two, death of the complainant. So, absence of the complainant can be the result of his death also. In such a case, the magistrate can adjourn the hearing of the case and permit the son of the deceased complainant to proceed with the complaint. This was so held by the Kerala High Court, speaking through Justice Pareed Pillai, who was later the Chief Justice of Kerala High Court. Jayarajan versus Jayarajan, 1992, Volume 2 KLT 586. 1992, Volume 2 KLT 586. Then comes Section 257, Withdrawal. Section 257 applies only to summon cases instituted on private complaint. It was so held by Kerala High Court, speaking through Justice R. Basant in YP Baiju versus State of Kerala, 2007, 4 KLT 1082. That is, 257 applies only to summon cases instituted on a private complaint, not to summons cases instituted on a police report. Withdrawal of the complaint and consequent acquittal of the accused in a summons case instituted on a complaint cannot be made in the absence of a request for withdrawal of complaint. There has to be a specific request for withdrawal of the complaint. There cannot be an assumed withdrawal. The complainant has to specifically request for withdrawal of the complaint. Then only the court will be justified in withdrawing the complaint. It was so held by Justice K. Hema of Kerala High Court in B. Uday Kumar versus Boban, 2007, 3 KLT 247. 2007, Volume 3 KLT 247. In the absence of compliance with the precondition in the form of a request for exercising jurisdiction under Section 257 CRPC, the matter was remitted to the trial court for deciding afresh in accordance with law by the Supreme Court by Justice G.B. Pattanayak and M.B. Shah in Provident Fund Inspector Tirupati versus Madhusudana Chowdhury, 2000, Volume 9 SEC 506. There, in the absence of compliance with the precondition in the form of a request for exercising jurisdiction, I told you Justice Hema of the Kerala High Court had taken the view that unless there is a specific request for withdrawal from the complainant, it is not permissible for the magistrate to withdraw the complaint. Here also, in the absence of a specific request for exercising jurisdiction under section 257, the Supreme Court remitted the matter to the trial court for deciding afresh in accordance with law. A complainant figuring as a private public interest litigation. A complainant figuring as a public interest litigant after pursuing his case against quashing of the criminal proceedings up to the Supreme Court. There is a request for quashing the complaint instituted by a private complainant in the form of a public interest litigation. There was a request for quashing the complaint. He resisted all the requests right up to the Supreme Court. Then, after that, instead of fighting the case, he sought withdrawal of the complaint. Supreme Court said nothing doing. You can't withdraw the case after having fought up to the Supreme Court and resisted the attempt to quash the proceedings. It will be against the discipline of the court. Sambat Singh versus State of Haryana. Sambat Singh versus State of Haryana. 1993, 1 SEC 561. Justice Ragnavel Pandian is the author of the judgment. The other judge was Justice Jayachandra Reddy. Justice Jayachandra Reddy. Then we come to the last section, 259. Section 259, conversion of summons case into warrant case. This section, which is a new provision, empowers the magistrate to convert a summons case into a warrant case if the offence is punishable with imprisonment for more than 6 months. And if the magistrate is of the opinion that it would be in the interest of justice to try the case in accordance with the procedure for trial of warrant cases. Because the case merits trial, warrant trial procedure. Magistrate is of the opinion that the case merits warrant trial procedure. In that case, magistrate can convert the summons trial procedure into warrant trial procedure. And, only thing is, magistrate should commence the proceedings de novo, afresh, from the very start. With that, we come to an end of this session. That is, trial of summons case instituted on a private complaint under Chapter 20 CRPC. Mr. Vikas. Hello.
Thank you, sir, for sharing your knowledge. And as you always speak, that we always learn something new whenever your session is there. And despite that you had called, you kept the promise of holding the webinar. We are always invited. Thank you, everyone. Be safe and be blessed. Namaskar.
Thank you.